Julianne. How are you today?
Sorry, nice to see you.
Well, we have Julianne Kocer here today, and she's going to be talking about trust and the different types of trust. So, if you can give us a little bit of background about you, and then we'll talk about the trust, and we're going to learn a lot. I know it. So, take it away.
Thanks, Ryan. Thank you so much for inviting me. I really enjoy educating people on various topics that affect their lives. I am an estate planning, elder law, disability attorney. I'm originally from Rochester, having grown up here. I attended law school up in the cities at William Mitchell College of Law, which then, after I graduated, merged with Hamline University. And upon graduation, I moved out to Washington State because I was engaged to a fellow classmate who is from Washington State. So I began my legal career out there. I was out there for 17 years. And then I moved back to Rochester to be closer to family. And I moved back with my son. He was in second grade at the time. My office here in Rochester is over on West Circle Drive. And I've been practicing I just celebrated last November 25 years.
Well, congratulations.
Yeah, thank you. It's gone by.
It went fast, didn't it?
Oh, it really did. Yeah, it did. And I celebrated with my clients. We had an anniversary week where we were giving away gift cards, having fun activities. We had a food drive. It was really a good time.
Oh, nice.
Yes. So I practice estate planning for people of all ages, all wealth levels. Estate planning,
Okay.
wills, trusts, powers of attorney. Elder law is actually a higher level of estate planning. And what I mean by higher level is it's not traditional estate planning. And I want to rephrase that. It's actually traditional estate planning and more. Why? Because traditional estate planning fails us all. Elder law really should be called asset preservation law. It's not just for seniors. It is for people who are disabled at whatever age, healthy people who become disabled. As an elder law practitioner, we're looking to how we can preserve assets because now at a younger age, we have to pay for long-term care expenses. So knowing how to navigate through the care system, knowing how to maybe turn to the government program to qualify for some of the benefits that our government provides for us. And it's an enjoyable area of law. And then disability law. Disability law is helping families that have a special needs child provide for that special needs in their estate plan by maybe implementing a supplemental needs trust. Also working with disabled individuals themselves and creating their own estate plan, creating a special needs trust for them.
So we were talking about trust as well. Can you go into a little bit more detail regarding that?
Trusts in kind of two categories.
Okay.
Revocable trusts and irrevocable trusts. So with a revocable trust, when it comes to estate planning, it is only a method to distribute assets when we die. So estate planning is more than just giving somebody a will and telling them to fill out a healthcare power of attorney and directive and a financial power of attorney. It's more than that. And if that's all that the attorney is doing, well, then they're failing the client. You have to look at how do we distribute assets when you pass away. That's estate planning. There are 5 methods to distribute an asset when we pass away. The first is a joint tenant on the asset that has right of survivorship. So joint tenancy with right of survivorship. The second method is a beneficiary form. Completing a beneficiary, we do that very common with life insurance, our 401ks, 403bs, investment accounts, we might list a beneficiary form. The third method to distribute an asset when we die is a revocable living trust. And a revocable living trust is an extension of ourselves. It's attached to us. It's like the purse that we're putting over our shoulder. And we actually place assets, retitle them out of our name, and place them into our trust. We have full control over the assets in the trust, just like our purse. We're able to go in, we have unfettered access. We can pull the assets out of the trust back into our name. That's what we mean by revocable, the ability to pull it back after we've transferred it in. We don't lose any rights to a revocable living trust, and there is no tax benefit whatsoever to a revocable living trust. So it's just a method. It replaces a beneficiary form method. It replaces a joint tenancy with right of survivorship distribution method. But more importantly, it avoids the fourth method to distribute an asset, which is the will. When assets come through the will, if it's personal property and household goods and it's more than $75,000 in value, we have to probate that will down at the courthouse to get the executor, which is now called personal representative, appointed. If we have real estate coming through the will to be distributed, then we have to probate that will in order to get the executor, now called personal representative, appointed to have the authority to distribute that real estate according to the heirs mentioned in the will. Well, a lot of people are, Julie, I want to avoid probate. How do I avoid probate? I said, well, you got to avoid having assets come through the will. So you have to look at the three previous methods. We have an asset. Can you list a joint owner with right of survivorship? That's very common with marital couples. The second method is a beneficiary form. And then the third method is a revocable living trust. So with a revocable living trust, we can place particularly our real estate into that trust. So the revocable living trust, again, avoids assets coming through the will, and we avoid probating the will. So we'll put our real estate into the trust. We'll put our personal property and household goods. And if we own property in more than one state, we're going to put that property of the other state, like Arizona or Wisconsin, also into the trust.
Okay.
And that's really one of the main reasons why we implement a revocable living trust.
Okay.
Really to avoid probate in multiple states in which we own real estate. Every state says, hey, if you're a human being and you die with real estate in our state, you got to come through probate so we have clean title transferring over to those heirs. Well, okay, so we'll put the Arizona property, the Wisconsin property, our Minnesota property into a revocable living trust. That's going to avoid probate in those states. It also then is going to act as privacy because the trust is never recorded, does not have to be recorded.
Oh.
Yeah. So it's private. So there's some privacy there. Some people say a third reason to implement a revocable living trust is you want to avoid creditors. You want to avoid creditors making a claim against the estate. You want to avoid paying your creditors. Well, it doesn't work 100%. If your heirs and beneficiaries, they know of a bill that has to be paid, we got to be on the honor system and pay the bill. But with a trust, there is no requirement to publish notice to creditors that says, hey, this individual passed away. Do they owe you money? If so, make a claim. That process falls under the will process. So if assets coming through the will, we're probating the will at the county courthouse, and then we have to publish notice, and then that's when creditors can make a claim.
Okay.
We're avoiding that process if we implement a revocable living trust.
At what point should somebody get a trust? What age? Is there an age? Is there a...
If they own real estate and they want to avoid having that real estate come through the will and avoid the court process of probating the will, it doesn't matter how old they are. If they own real estate, they might want to consider having a revocable living trust.
Okay.
If the individual does not own real estate, well, then I can look at what assets they do own, and maybe we can have it distributed through the beneficiary form method or the joint tenancy with right of survivorship method. So also, if we just have personal property, we could have a will and just have our personal property come through the will, but it's less than 75,000. Our personal property, household goods, and vehicles are less than 75,000. And we are avoiding a probate, and then we also do not have to implement a revocable living trust.
And now vehicles are 75,000. So you probably do need to include those.
Yeah, they're getting up there in price, that's for sure.
So I've also heard about an irrevocable trust. When does that come into play?
Well, an irrevocable trust is when you transfer the asset to the trust. That's it. You're done. You're locked in. You can't change your mind and revoke that action and pull it back like you can in a revocable living trust. An irrevocable trust is a means to get the assets out of your estate. So maybe we have a couple that wants to make a sizable gift to an irrevocable trust for the benefit of their grandchildren or college. Well, we can do that. Of course, we have to keep in mind that if these children are under the age of 18 and we're making gifts, that we have to give notice and we have to set up crummy trusts instead.
Okay.
That comes after the gentleman who invented that type of trust. That's
okay.
a different topic for a different day. But an irrevocable trust is technically, you've given the asset away. That irrevocable trust is its own legal entity. It has its own tax ID number, and the asset is not in your estate.
Okay.
Subject to further distribution when you die.
Okay. What would be the average cost of a trust?
It depends. It depends on how much drafting the lawyer has to, prepare for the client. And, it can start at 1,000. If the client says, you know what, I've got animals, I want a pet trust. I can draft a pet trust in the revocable living trust. So then that might be an additional $500 for the pet trust. Maybe they want a child trust or a grandchild trust, and that would be also drafted within the revocable living trust. So the price does vary on the amount of drafting the lawyer has to undertake for the client.
I know this is probably a weird question, but why would somebody want a pet in the trust?
Well, let's say that they do want to leave a dollar amount to a trust that will help pay for the care of their animals after they
Okay.
They don't want to burden the individual that they've selected as the caregiver for the animal. So they can put funds into trust. There could be a trustee that then, reimburses or directly pays for the care of the animal.
Okay. Now, let's say somebody wants to, for example, donate part of their estate to an animal shelter. How would that be done? Would that go into the trust as well?
Like one of the beneficiaries. So we want, several of my clients do have beneficiaries that are charities. And so we simply mention in the trust that the assets in this trust when I pass away are distributed to the following persons and or entities in the following percentages.
Okay. And was that something that you would also put in the will?
Question. When a client has a revocable living trust, do they need a will? And I say yes. We need will as a means of last resort. So I'm working with the client and I'm saying, all right, these are the assets that are in your room as we sit here today. These assets are going to be distributed through your revocable living trust. These assets are going to be distributed through the beneficiary form. These assets are going to be distributed to the joint owner with right of survivorship that's listed on the account. Then a couple of years later, the client, attains another asset. Maybe they got a bonus from their employer. Maybe they inherited some money. They go to the bank, they open up a brand new account, they deposit the money into that account. They didn't list a joint owner on the account. They didn't list a beneficiary form on the account. They didn't put it into the name of their trust. Well, then now the will distribute that asset. So we need the will as a means of last resort. So the beneficiary under that will is the trust. So then the asset coming through the will get kicked over to the revocable living trust for final distribution.
Okay. Is there anything else that you would like to share with us that maybe somebody doesn't know, the general population doesn't know? Maybe especially as a way to avoid probate.
Like something in regards to another method to avoid probate. I think, Lori, something great is, as an elder law attorney, I get asked the question about an asset preservation trust for Medicaid planning, medical assistance planning. And what is that? Well, that is a defective revocable living trust. It's irrevocable, meaning that once we transfer the asset in, we can't change our mind and pull it back, but the asset in that irrevocable asset preservation trust then goes to our heirs when we pass away with a date of death value. But the assets placed into that trust, it's irrevocable. We placed that asset into the trust more than 5 years ago. So now we're going to qualify for the government program. And the question that we're asked in the application is, did you make any transfers to individuals or trusts within the last 5 years? And the answer is no, I transferred it in 5 years and 1 month ago, or more than 5 years ago. So we answer no. So the assets placed into an irrevocable asset preservation trust for medical assistance, Medicaid planning, those assets are not counted toward an individual's eligibility to go on that government program.
Okay. So 5 years and 1 day is the magic time.
5 days and 1 month.
Okay. Is there anything else you would like to add?
Now, clients will come and see me and they'll say, Julianne, we've got this revocable living trust that, of course, we implemented as part of our estate plan. Are the assets in this trust counted toward our eligibility for the government program? And I'll say yes. And they'll say, well, we put it in there more than 5 years ago. And I say, but it's a revocable living. It's not an irrevocable asset preservation trust. So big distinction there when it comes to asset preservation, qualifying for the government program. How can we preserve assets?
Okay. Well, if you don't have anything else to add, I just again wanted to introduce Julianne Kocer, and she's with Kocer Elder Law. And we're going to there's some information at the end of this interview. And so you'll be able to email or contact Julianne with any questions. And thank you so much, Julianne. This is going to be so informative to the people that watch this.
You're welcome, Lori. Thank you so much for the invitation.